Dispute resolution and crisis incident management. First is negotiation. Negotiation is a process where two parties in a conflict or disagreement try to reach a resolution together. During a negotiation, the parties or their representative discuss the issue to come to a resolution. Before a negotiation, each party should consult a lawyer. Consulting a lawyer allows each party to be well aware of their rights and duties for the matter what to resolve. Principle of negotiation. The reason to negotiate is to produce something better than the result that you can contain without negotiation. Fisher, etc. 1991. The goal is to reach an agreement that is acceptable to all parties, to which they remain committed and which they indeed implement. This is essential of interest-based negotiation, which has the following principle. Interests are needs, food, shelter, security, and so on. Desire, aspiration, fear, hope, and concerns. Position are what we want and demand. The interests are the reason behind the position. In negotiating on the basis of the interest, parties will need to first distinguish between position and interest, then more from position to interest, list all the interests according to priority. Think of position as always one of many solutions to the problem. The second is mediation. Mediation is a process where a neutral person assists the parties in discussing the matter and reaching a resolution. A neutral person is a person who does not support either party in the conflict. This person is called the mediator, and they help the parties communicate. A mediator ensures that communication between the parties is fair and honest. The mediator is not a judge or an arbitrator and cannot take the side of either party, give legal advice, or provide counseling. Mediator can assist by clarifying issues, identifying concern, and helping parties understand each other's interests. The mediator can assist the party in reaching an agreement between them, but will not force the parties into a solution during mediation. Mediation takes place in private and the decisions made are private. Mediation can take place in a person where parties meet face-to-face or discussion, or the parties may be placed at separate location where the mediator communicates information between parties. After mediation, the parties can sign a Memorandum of Agreement or MOA. A MOA is a cooperative agreement written between the parties to be obeyed the agreed term and condition. The mediator writes the MOA, which outline details of the solution reached by the parties. The purpose of MOA is to have a written understanding of the agreement between the parties. Each party should have their lawyer review the MOA. An important subject for mediator is how to distill from the various code of mediation ethics the essential principle that this code have in common. Such code is common, with something different provision have been developed by the Society of Professionals in dispute resolution. The 10 principles outlined below are the compilation of what I believe are commonly accepted principles of mediation. 1. Conflict of interest. 2. Competence or professional role boundaries. 3. Impartiality. 4. Voluntariness. 5. Confidentiality. 6. Do not harm. Do no harm. 7. Self-determination. 8. Informed consent. 9. Duties to third parties. And the last, then, honesty. Then the third is arbitration. Arbitration is a process where a neutral third party makes a decision. The decision maker in arbitration are called arbitrators. There can be only arbitrators or multiple. The arbitrators will arrange a meeting between the parties to determine what issue need to be resolved during the arbitration. Each arbitrator hears the parties, present their case and their supporting evidence. The arbitrator may also require each party to provide their case and supporting evidence in writing, called writing submission. After hearing both parties' side of the story, the arbitrator will make a decision. Arbitral decisions are sometimes called award. Arbitral awards are the generally final and compulsory. An award may be filed in court and enforced as if it were a court judgment. It can often take a long time to receive an arbitration award. Arbitration is common in commercial disputes, consumer and employment matter, family disputes, or insurance claim disputes. Arbitration has many advantages over court hearing and litigation. For example, arbitration can be faster, more flexible, and less argumentative, intimidating, and expensive. General principle of arbitration. The object of arbitration is to obtain a fair resolution of disputes by an impartial third parties without unnecessary expense or delay. 2. Parties should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in public interest. 3. Courts should not interfere. Then next we have reconciliation. It is a method of facilitating frank engagement between minority communities, police and other authorities that allow them to address historical tensions, grievances and misconceptions and reset relationship, respect, collaboration and effective working relationship between the police and the communities. Are centered to both community safety and effective policing. However, in many communities where serious is constructed, mutual mistrust and misunderstanding prevent police and communities from working together. Principle of Reconciliation. 1. The United Nations Declaration on the Rights of Indigenous People is the framework for reconciliation at all levels and across all sectors of Canadian society. 2 is the First Nation in Inuit and Métis people as the original people of this country and as self-determining peoples have treaty, constitution, and human rights that must be recognized. 3. Reconciliation is a process of healing of relationship that required public truth-sharing, apology, and commemoration that knowledge and redress past harm. 4. Reconciliation requires constructive action on addressing the ongoing legacies of colonialism that have had destructive impact on Aboriginal people, education, culture and language, health, child welfare, the administration of justice and economic opportunities and prosperity. 5. Reconciliation must create a more equitable and inclusive society by closing the gap in social, health, and economic outcome that exists between Aboriginal and non-Aboriginal Canadian. 6. The perspective and understanding of Aboriginal elders and traditional knowledge keeper of the ethics, concept, and practice of reconciliation are vital to long-term reconciliation. 7. Support Aboriginal people cultural revitalization and integrating indigenous knowledge system, oral histories, law, protocol, and connection to the land into reconciliation the process in essential. And last 8. Conciliation required political will, joint leadership, trust building, accountability, and transparency, as well as a substantial investment of resources.